Hi, everyone. Thank you for attending today's session, Mental Health and the Crossroads of Indigenous Persons, Bail and Sentencing. Today's session will run about 50 minutes with time at the end to answer questions. Please post any questions in the chat box. We have received a tremendous response to this webinar and we are hosting a large audience. If you experience technical difficulties, we suggest you exit the meeting and re-enter it using the link provided in the email. Rest assured that LexisNexis will distribute a recording of today's session in a follow-up email. Now we will meet today's presenters. Cassandra DeMelo is the founding lawyer at DeMelo Heathcote in London, Ontario. Her practice focuses on criminal defense, but especially enjoys it when it intersects with mental health and addiction issues. Cassandra speaks Portuguese and Spanish and holds executive positions with the Criminal Lawyers Association, Ontario, Women in Canadian Criminal Defense, and is the president of the Criminal Lawyers Association, London. Naomi Sayers is a lawyer and Indigenous feminist called to the Ontario and Alberta bars with nearly a decade of consulting experience. She worked in-house at one of Canada's largest electricity providers. She has appeared at all levels of court in Ontario: Federal Court, Trial and Appeals, Alberta Court of Queen's Bench, and various tribunals throughout Ontario. Ms. Sayers represented WorkSafe TwerkSafe, the first and only federally incorporated nonprofit advocacy group dedicated to strippers' rights to work safety in Canada. Shauna Kelly is an Anishinaabe Canadian Irish and works with Indigenous Justice Division of the Ministry of the Attorney General. Before working with MAG, she practiced as a criminal defense lawyer for 13 years and was an elected member of the Criminal Lawyers Association Board of Directors and was the Gladue Court representative to the CLA. Her criminal defense practice focused primarily on representing Indigenous people in Toronto. I will now turn it over to Shauna, who will be moderating today's event.
Perfect. Thank you so much for that. And thank you everyone for joining us today. I really appreciate everyone coming to join us for this discussion. And I'm just going to go right into our very first question. And the first question is for you, Naomi. Can you help us understand the concepts of intergenerational trauma and explain to us how that plays out in the justice system?
Yes, so intergenerational trauma, is one of those terms that it's literally what it means. It's intergenerational and it's trauma. So it can be passed down from generation to generation. So say, for example, today you have a client who's impacted by alcohol and drug use, and poverty and other intersecting issues of marginalization. But he has a history, and that history is a result of the family home being impacted by the Indian residential school system. So say his mom and dad and his grandparents had gone to either Indian day school or an Indian residential school and were forced out of their homes, taken away, and those family relationships impacted. Obviously, that will have a very disparate impact on your client's upbringing and experiences, and it may impact them within the community where they play out the responses, and whether it means getting involved in the justice system out of survival or just marginalization, right? So if you have a hard time keeping a job, or if you have a hard time keeping a home, what's going to happen is that you're going to be impacted by surveillance of the state, and obviously criminalization. So that's how intergenerational trauma plays out. The Truth and Reconciliation Commission has a nice summary and nice reports that individuals can review in terms of how it looks on for individuals, but how it plays out in the justice system is just exactly that. Somebody can, have a hard time keeping a job, and that can impact how they have their own basic needs met: food, housing, shelter, and just being kept safe. And then in order to do things, in order to survive, they do things that generally Canadian society doesn't deem acceptable. So their behaviors are then criminalized. So obviously involving property offenses and sometimes substance abuse offenses, so CBSA charges, and then can also play out in terms of intimate partner violence.
And so taking into consideration some of those, the way that intergenerational harm manifests itself in the individual before the court, can you then draw the connection to how to deal with the mental health issues that may arise from the intergenerational trauma? And in particular, I'm hoping that you can help us or help explain to us the culturally appropriate tools in relation to any of those mental health issues and what those culturally appropriate tools may look like.
Yes, so that that is probably one of the bigger issues, just from a defense counsel perspective, in representing Indigenous clients, is that it's actually really hard to find culturally appropriate tools, and so you really have to advocate for your client in those circumstances. But that also means that you have to just also step up to the plate and maybe do a little bit of extra work in terms of reaching out to services that may connect to your client and help them find culturally appropriate tools, or tools that they would want to participate in terms of their involvement in the justice system. So one example that oftentimes we don't talk about as defense counsel and representing Indigenous clients is the Indian Friendship Centers. So almost every major city center has an Indian Friendship Center, or there's a nearby Indian Friendship Center, and they have services and court services, and they can really assist your client in a way that you probably, as defense counsel, may not have the capacity to. So to really, some clients don't even want to talk about their past to you, right? And even me, and so I accept that, but they'll talk to the court caseworker from the Indian Friendship Center, right? Somebody who's not a lawyer, but who works with the community and who would be able to build that story for you, that storyline for you, and help them connect to also just culturally appropriate tools.
Perfect. Thank you. Now, I just want to kind of turn to the case law and the guidance that's provided to us by the Supreme Court and other courts, if you want to include them, but specifically in Gladue and Ipeely. Are there any specific considerations from the courts on how the Gladue principles and factors have impacted mental health proceedings?
Yes, so just a brief summary for our listeners. Gladue and Ipeely, sorry, I always mess up the pronunciation. So Gladue says, we must consider colonialism and its impacts on Indigenous people. And Ipeely says that we don't need to meet a high threshold for evidentiary burden. So we don't need to file expert evidence. We don't need to bring an expert in to discuss how the Indian residential school or colonialism impacts Indigenous clients, and tribunal decision makers and decision makers in the courts are entitled and can, and I would argue should, take judicial notice of how colonialism has impacted Indigenous peoples. I'm aware of case law where sometimes Gladue factors are raised and decision makers just bypass it. So it's how it has impacted mental health proceedings. It's really a professional obligation for defense counsel to raise those considerations when and where they can, and obviously with the assistance from the client, because the client can also be in a situation where they don't want to raise it for whatever reason. They don't want to raise it, And so it's important to, in that moment, to obviously get written instructions or get instructions as best as you can as to, they don't want to raise it, and you've explained the risk of them of not raising GLADU factors. In terms of the case law, though, it has, I wouldn't say there is some helpful case law in terms of, culturally appropriate treatment must be provided. But there are some case law where I don't agree where they apply GLADU. So it's really important for defense counsel to really look at what's happening in terms of what are the courts saying, and more importantly, what are they not saying, and to really draw that attention out to the decision makers and say, this is what GLADU says, and this is why it's important, and to really draw that point home for mental health clients.
Perfect. Thank you. And in just a moment, we are going to move into the issue of bail as it relates to mental health. And Cassandra, I will turn it over to you just momentarily, but I'm just going to ask Naomi one more question. And that's in relation to fetal alcohol spectrum disorder. I know that there's a lot of misunderstanding regarding fetal alcohol spectrum disorder and how best to service clients who have been diagnosed or identify as having fetal alcohol spectrum disorder. Can you help us understand what the justice system can do better to approach individuals who present with this disorder, both maybe as practitioners and before the court?
Yes, so that is a really important question in terms of just assisting mental health clients, because one of the barriers to interacting with individuals who may have FASD is actually having the diagnosis. And so there are barriers in place to get that diagnosis, and there may be lack of services just to obtain the initial diagnosis. And there also may be, again, the client may not want to receive the diagnosis due to, stigma, shame associated with the diagnosis. But it's really important, again, to explore that with the client, and, maybe they don't understand, but to really just to make sure that you really connect them with the services that who may explore, that connecting them with a practitioner, a healthcare practitioner who may be able to help with that diagnosis. So, for example, CMHA or again, Indian Friendship Centers, they have connections to healthcare providers who will assist and who can direct, the pathway to those supports more quicker than defense counsel can sometimes. But in terms of what the justice system could do to better approach this unique situation, I'm cautious about saying this, but perhaps maybe they might want to take judicial notice of the fact that FASD exists and it's prominent in some communities, and it impacts certain population groups at an exorbitant rate than others. And perhaps, not requiring the high threshold that IPLE says. I'm not saying that, all Indigenous mental health clients have FASD, but there is a large amount. And I think that requiring the official diagnosis is really an impediment to just fairness and justice for our clients.
Thank you. Yeah, and there's lots of interesting case law that's coming out of, I think, Alberta on that topic recently as well. So thank you. That's a very, very good point. Just before we move on to Cassandra, and I'm sorry, just going to ask you one more question, just in terms of recommended, if you were going to make submissions in court in terms of fetal alcohol syndrome and your client being before the court, is there any recommendations that you as counsel may make?
So again, I really sit down with the client and I really have that one-on-one conversation with them about, I tend to find that when the client is involved in that way, they feel as if they're being heard, and they feel like as if they are part of the process, and that even if they don't get the outcome that they don't agree with, they still at least feel a little bit heard. So I think that's really important to just to sit down and just have the client have some input. But in terms of submissions, again, it's really important to draw the barriers in place that may be impacting your client in particularly. So one example that I raise is oftentimes hospitals and treatment centers are far away from Indigenous communities. And to me, that is just de facto, colonialism at its best, is forcing these individuals away from their family, homes, and communities, and requiring their family to travel or to visit them only via telephone or Zoom. So we have to really draw out how that may impact the treatment of the clients, and to really highlight how that is a barrier and not may not be supportive to the client's treatment.
Yeah, I absolutely agree. Yeah, thank you for that. So Cassandra, I'm going to turn over to the next portion of our questions. We'll tie it in all together afterwards. And that is the intersection of mental health and bail. And we're going to hopefully draw in sentencing as well. I wondered if you could start us off by giving us a legal framework for bail, and how it is that we can see mental health concerns play a part in that process.
Sure. So thanks for having me, first of all. I'm really excited to be here. I want to just kind of give the context for my comment. So I did my master's a little while ago, and that really was the background to my work on mental health and bail. And what I set out to answer for myself was a question of, is there something more we can do at the bail stage in order to, quote, help people who have mental health issues, or should we even be doing that? And really, at the end of the day, the answer that I came up with was any options that are available at the bail stages to assist with mental health need to be very, very carefully approached. And to the extent that we are ever trying to help someone at that stage, no matter how genuine the desire is to help, we need to be cautious of not imposing a term that is otherwise not necessary, and therefore just setting your client up to fail. And so I actually changed my own mind about that as I was doing my research, because at first I almost approached it as like, can we do something more to address these mental health issues sooner? And then by the end, I became convinced that we need to, be careful at all costs, in fact. So that's going to be a theme that you see throughout, because what we don't want to do is go against some of the case law that I'm going to talk about today, like Zora and whatnot, that basically says like there needs to be a reason tied to the allegation for the condition, and not just a condition because a court has a well-meaning intention. They think this person, is having a psychiatric episode or something, and they want to get them some help. Sureties likewise can be really well-meaning, but it's just not the correct place is in the bail court for those considerations, or at least not as a term, so to speak. So all of my comments today are with that, experience in mind, and my own having to convince myself that we need to be very careful that if there's ever an opportunity to help someone, it has to be with their consent. First of all, that's when it's the most helpful to them. But second of all, that probably the criminal justice system is not the right tool for that help in most cases. And that's a really sad reality, because I think most of us get into this area of law wanting to be helpful and wanting to help change the system, right? We recognize the problems with it, and we recognize that there's lots of work that could be done. And so how you handle those issues is a really big scale problem that I'm not claiming I know the answers to, but I think I know, what not to do probably more often than what to do. So I'll break it down by talking about the framework of bail and how we can see this play out. And I know that most people attending this session today are here probably because you're some sort of criminal law practitioner. So sorry if I'm oversimplifying it, but just in case there's anyone new to this area, I want to make sure I've covered off the bases. As we know, bail has a laddered approach. And so essentially you start off at like very low terms, probably a release from the police station with maybe a promise to appear, maybe some terms, and you work your way up from there to recognizance, either recognizance on your own or with a surety. And then, you know, it gets all the way up to potentially house arrest with the residential surety. You've got ankle bracelet options. And so when we are considering what level of bail to use, of course, we are always thinking about primary, secondary, and tertiary considerations. And interestingly, the history of bail, going back to its originating days, we were only ever concerned initially with primary considerations, which was getting the person to court, making sure that they show up. Secondary considerations really only came about in more recent centuries. And then tertiary grounds, of course, are a pretty recent idea in the last, 100 years or so. And so we now have this system that is almost more focused on secondary grounds, I would say, than primary grounds. Like, of course, we care about primary grounds, but oftentimes if there's a contested bail, it's on the secondary grounds, right? And so secondary ground concerns with mental health becomes really interesting because the very thing that may well be playing into the criminality, if of course the person has actually done the thing they're alleged to have done, is also perhaps going to be seen as the thing that needs to be controlled, so to speak, by way of the bail order. And that's where you see courts really struggle with how do we get this person, quote, help, to ensure that they don't do this again, or that their mental health doesn't get in the way again, basically. And again, as well-meaning and maybe perhaps an appropriate question as that is, we just, first of all, lack the tools and lack the terms and the programs as part of bail to really even start addressing those issues. But second of all, back to my initial point, which is, should we even be doing that? Are we setting the client up for failure? And so every step along the way, when you're considering what bail, like if you're the defense counsel, for example, and you're considering what bail level to offer to the court, I often describe it this way. I offer the Cadillac, but ask the Crown to only accept the Pinto. And so give them as much as you can, but say you don't actually need all of that. And so with mental health considerations, it's the same idea. If you've got a surety who's really well-meaning and wants your accused person to go get counseling and get some help, either rehab if it's like a drug addiction issue, or perhaps go see a counselor against their will because they know they're dealing with depression, but that person can't see it. Whatever it is, you equally need to be having those conversations with all parts of the bail plan. That means the surety, that means the Crown, right? That means everybody, the accused, of course, and not just agreeing to something because it's easier to get a consent release and walk out the door than it is to actually fight back on the terms. So setting reasonable expectations for everyone involved is important. And when we are talking about a surety, that becomes especially important because they will control your client to a certain extent and have a certain amount of leverage over them. So keep that in mind at that stage. What we often see as well, though, is that when there is mental health disorder at play, those are the people that are sometimes less likely to have a support available to be your surety. And so what that means is you're now maybe needing to be creative with how you approach bail and how it is that you're able to get bail for the person who otherwise doesn't have a great support system and certainly no one to come forward to be their surety. And so when you are faced with that issue, similar to Naomi's suggestion about, Namron Friendship Center in London is our Indigenous Friendship Center. They're fantastic. They do fantastic work. They help with bail actually in London as well. So you can get a bail plan worked out with them if your client's Indigenous, and that can be part of the plan. But for non-Indigenous folks, we equally have other programs available. So again, I speak to what I know. So sorry that I tend to resort back to London, but in London, we have the John Howard Society. They can offer bail supervision programs. And you otherwise may be able to fashion some sort of term that is less stringent on your accused, but still meets the ends of the concerns for bail. For example, having them report to the police station once a week or something like that. Like if transiency and mental health and those kinds of issues are all intersecting, think of ways that you can have that person be accountable and make sure that they're showing the court that, they're following the rules without being overly stringent on them. And that becomes extra important when you are genuinely concerned that mental health issues are at play, because sometimes that mental health issue will prevent them from being able to follow terms that would otherwise be reasonable for someone else. So sorry, I've kind of gone on a lot of different angles there, but I'm trying to cover off as much as I can in a short amount of time. So
that's okay. That's actually where we're at right now is actually a really, really great transition into the next discussion. And that's the effect that Zora has on the accused person seeking bail and living with mental disorder. I mean, everyone is hopefully familiar with the decision of Zora, but maybe you can just help us understand that and the connection and the effect that it may have had on bail proceedings.
Yeah, so Zora was a welcomed decision, of course, because it repeated what we already knew in a lot of ways. Of course, Zora dealt with the mens rea issue on breaches too, so it was a dual purpose decision. But as it related to the opportunity to speak about bail, it was really welcomed because I think every few years we all as a profession become a little bit complacent. We get used to the day-to-day and the humdrum, and we start to forget the principles because it just becomes mundane, right? And then, you have an example that comes about that you're like, oh yeah, like this needs to be connected to the term, like to the actual allegations. So a really great example is, if someone's charged with theft under, and they're not even alleged to have been under the influence at the time of it, but it turns out that they admitted to duty counsel or to their lawyer, whoever's helping them with the bail hearing, that they have an alcoholism issue, then it is completely inappropriate to put a no alcohol term on that person. And we can talk about that term in a number of different contexts, like even if that is part of the problem of maybe why they committed an offense, allegedly, you should not be offering that term anyways, or even agreeing to that term. But my point is, it would be completely inappropriate to add that term simply because someone somewhere noted it as a potential issue for this person, right? And we were starting to see that again. We were starting to see bail orders come out that were becoming more and more restrictive, and we were starting way too high on the bail ladder. And, we see this get legislatively doubled down on when, for example, we see the amendments to the criminal code, and they again repeat, we should be restraining our use of sureties. We shouldn't be jumping right to a surety release. And these are all concepts that Zora also discusses, right? We need not assume, even after, a few times of someone being released on bail and continuously being brought up on new charges, I don't think we then need to immediately jump to surety release. Like, it really needs to be a considered approach where the use of a surety, for example, or the use of more stringent terms are only being implemented because it is rationally connected to the allegations. And Zora was the reminder of that. It didn't say anything super novel. It just reminded us again that this is what we should be doing. And so I don't think there's a bail hearing that goes by where I don't mention Zora. I would be surprised if most other people, didn't mention it in passing at the very least. I think it does play a part in the back of a lot of people's mind as we go through the bail steps. But I really do want to make sure that we remind ourselves too, especially if you're defense counsel, especially if you're Crowns, if there's any Crowns listening, to really consider what do you actually need to meet that secondary ground or tertiary ground concern. And if it doesn't involve, a fifth term that's not really seeking to accomplish anything specific, then don't ask for it, right? Don't make me consent to it just to give me the consent release with my client. Be the Minister of Justice that, it sees that this is all I need and that's going to meet my grounds concerns. And therefore, that's all I'm asking for.
And so that's actually great. So in light of those comments in terms of the what not to recommend and not the overuse of the terms and conditions, I'm just going to ask you this. How can legal participants perhaps use bail to help the accused who's living with mental health disorders? And should that be the goal? Should helping the client be the goal of the bail?
Yeah. So I hearken back to my comments before about probably not. I think especially when you have new counsel, younger counsel, we tend to, be bright-eyed and bushy-tailed and want to help the world. And we still think we can do that on every single case. If you still have that amount of enthusiasm, I applaud you. I myself am becoming a little bit more cynical, but I try not to. And so, yeah, it becomes a realization that we cannot help the mentally disordered accused person in the criminal justice system, especially not at the bail stage. I really don't know that there's the proper infrastructure, first of all, or the tools to do that, or should be. And again, it all kind of comes back to this idea of, as well-meaning as it may be, and as much as your client in the moment, you also have to realize there's a power imbalance. If your client's in custody and saying, I'll do anything to get out, I'll do counseling, I'll do this, I'll do that, they're in a vulnerable situation where, of course, you're going to agree to everything. But then when they get out, the realities of the world are much harsher, and their mental health will continue to play a precarious role in that. And we really need to be cautious that whatever we're setting them up for is, as I've said before, not going to set them up for failure. So it's important that we try to keep those systems separate, even though they do, of course, interact. And I mean the mental health system and the criminal justice system. We want to make sure that if someone wants some help, that they're getting it. So for example, myself in my own practice, if I have someone who I genuinely think is looking for help, like maybe this charge was the thing that is rock bottom for them, and they now realize that they need to seek help, then outside of bail court or outside of sentencing, I will work with them to get them that counselor, to get them connected with whoever it is or whatever it is that they need. But that is work that I think is most appropriately done outside of the courtroom, and will help your clients in the long run if you can then show, like, hey, on their own initiative, they went and they did this program and they completed 12 courses, like 12 sessions, and here's their letter of certificate of graduation or whatever you want to call it. Or they recognized after they were charged that they were struggling with PTSD or anxiety, and so they went and they sought a diagnosis, and now they're seeing a psychiatrist regularly. Like, those are the kinds of things that I'm not saying we should devoid the criminal justice system of even thinking about these things, but it's just the way that you employ them. And so what I'm trying to encourage is not employing these things through the use of terms, which then could end up worsening the position for your client, because if they fail to complete that term or abide by the term, then they end up breaching, and that doesn't help them at all, right? So it's about, if they consent and if they want the help, then making sure that they are connected as best as possible, but outside of a court order. That's how I think we can best meet the intersection of mental health and criminal justice.
And so if we're talking about doing all of that work outside of a court order, I'm hoping maybe you can take us through some of the conditions. So going back to that court order and the conditions that you would be recommending to the court, take us back to those conditions outside of the bail context. What conditions would you recommend to account for the mental health concerns? And perhaps also maybe draw us a distinction between the shift in a sentencing order versus a bail order, and how the presumption of innocence or the loss of the presumption of innocence would affect the terms and conditions that you would be suggesting to the court.
Sure. So, of course, when we talk about bail versus when we talk about sentencing, there's some significant differences. And it would be negligent of me to suggest that the two are the same. Of course, once you get to sentencing and you've lost the presumption of innocence, and in fact, you are convicted or found guilty of what you're alleged to have done, the powers of the court are different, and the infrastructure to meet those concerns is different as well. And by that, I mean, probation orders, parole, if you're going to be serving a penitentiary sentence, and what parole officers can make you do. And so, of course, we often will see it almost every time an order with probation of attend counseling as directed, right? And so I do think that when we switch the conversation to sentencing, I have to approach it a bit differently, in that I recognize that courts are often going to include those terms and try to quote help or quote fix the issue. I just do wonder how much how far those attempts go when they're forced. And this is where I really try to take a holistic approach of mental health and criminal justice, in that it all goes back to consent and personal growth and understanding what the person individually needs themselves. I find my clients who have come to the recognition that they are struggling themselves and want that help themselves, they're the most likely to succeed when they then seek out or do use that help being offered to them. And so what I'm saying is, of course, I recognize in sentencing that we are going to see terms that try to at least offer and in some ways force that person to do counseling. I just question how successful it is, or how successful it can be, if that person is only going because they're court ordered. And so in other words, what I'm trying to say is, it doesn't really help the person to just go through the motions. Maybe they'll not breach their probation because they've attended, but have they actually gotten anything from it? I'm not sure. So I don't know what the answer to that is, because you can't force someone to care. You can't force someone to want to change. You can't even force someone to realize they have a mental health issue sometimes, right? And that's the reality that we're facing. And so, of course, we want to almost paternalistically say, well, we know what's best for you. So here's a court order telling you must go seek a counselor, because of course we think you have some issues that you've got to resolve and work on. I get the tension. I understand it, and I understand why the terms are put in place, but it is something that I struggle with as a practitioner, I must admit, because of my own, concerns or criticisms or wonderings of whether or not it actually achieves what it sought to achieve, which is fixing a mental health issue. Your first, I think I answered the last part of your question first. You then asked about conditions, like what kind of conditions could we include?
Yeah, so earlier we were talking about the terms and conditions, or sorry, we were talking about the approach that you would take outside of the sentencing realm. So what can you do for your client, and how can you help them outside of the conditions that you would be suggesting? So I'm just wondering if you can bring us back to the conditions that you would be suggesting to the court. What terms do help us, and take us through times that conditions can be placed on the accused in sentencing hearings that might try to account for those mental health concerns.
Right. So in keeping with what I've been saying, I at the bail stage, at the very least, I don't know that there are a lot of terms that we can add that would assist with mental health concerns, nor should we probably be dealing with it at that stage. If there was an opportunity to have a court-ordered assessment, like maybe the problem is that the person knows that they're struggling, but they just don't know what it is. If there was an opportunity for a court-ordered assessment for mental health, similar to the Section 34 order under the YCJA, that has some room to be helpful. Again, assuming that there's consent from the party for that assessment and that they actually want to do that and want to learn more about what's going on. But that's not a thing for adults, right? Like that, for adult accused, that's not an option. And so I really struggle with what terms to put in place at the bail stage that could be helpful and aren't just simply paternalistic. Even the term, for example, if you do have a surety who's really like hell-bent on, I want my accused person to go to counseling, and that's going to be one of the rules of living in my house, even the term of reside with your surety and be amenable to the routine and discipline of that house, like that could be difficult for that accused person to comply with if the surety's rule is, I want you to go to counseling, and the person says, I don't want to go to counseling, right? So again, if you already sense that tension between your surety and your accused person at the bail stage before you've even put this bail plan in place, again, it's about having reasonable expectations set with both parties. And maybe that's more the surety than the accused, although the accused also is in, again, the vulnerable position of needing bail or wanting bail at the very least. And maybe that's just something that they have to come to terms with. I don't know. I don't know that there's many terms that I can suggest. And back to my point about, I think mostly we're gone are the days of these terms, but please don't accept no drinking terms, no alcohol, don't purchase alcohol, even drug terms of not to be in the possession of a scheduled substance without a prescription, and all of those things. It doesn't do anything but set your client up for failure if that is in fact a problem. And in fact, there's a charge for possessing an illegal substance. So the federal crown, if they really want, they can charge your client that way if they are in fact later found to have that possession. So don't agree to those terms. As I said, I don't think we are as a profession very much seeing them anymore, but just in case there's any jurisdictions out there that are still employing those, I want to just make that point. Because again, in this spirit of, you think you're helping, it's not helping. If someone's truly an addict or an alcoholic, for example, telling them that they can't do that thing by way of a court order is not going to fix that problem. And so all you're doing is setting them up for a potential breach. And then I think I answered the question about the terms with sentencing already in my first answer, Shauna, so I'll leave that alone.
Perfect. Thank you so much. So I'm going to turn to Naomi now just to connect those everything that you've talked about just now about the terms and conditions. And Naomi, I'm going to ask you, what type of considerations would you be hoping that the court would consider when they have an Indigenous person who's also presenting with mental health concerns and they're about to be placed on a form of release, whether or not it's bail or diversion program or sentencing? So what are the considerations that you would hope the court is considering?
So I think it goes back to some of the points that Cassandra was making about whether they're connected to the allegations, and then also to a point that I was making that how, like, the more systemic high level overview, like how would this ameliorate the effects of colonialism on your client? In terms of other considerations, I'm a big proponent of how ensuring that we really hone in on the systemic impacts and hoping that the decision makers do take consideration of those systemic impacts and not replicating the effects of colonialism. So just for example, treatment centers may say we have culturally appropriate treatment, but I'm not sure how that can be true and applicable to every single Indigenous person, because there are lots of Indigenous cultural upbringings and traditions and teachings. And to have a treatment center say that it's culturally appropriate because it's an Indigenous program and it's being delivered to Indigenous clients, we really need to start questioning that and ensuring that colonialism is not replicated in the system itself.
Yeah, I agree. Yeah, questioning the who's developing these culturally appropriate programs, right? Yeah, I absolutely agree with you on there. I have a few questions that have come in through the question and answer. And Naomi, I'm hoping you can deal with the first two questions. They're both about the friendship centers and the tools that they can provide in terms of the services that are available. So the first question was, in what ways can the friendship centers help? What tools and services are typically available through them? And then the second question, which is tied, and I thought maybe we just address it at the same time, is how can defense lawyers help in getting a friendship center in their jurisdiction? So I can repeat that second question or either one of them at any point. I just want to read them both to you right now. Is there any direction you can give us on that?
Yes, so Indian friendship centers, I think it's really important to understand the historical, political, social context of Indian friendship centers. So Indian friendship centers are basically, I would say, advocacy centers historically, and they're sites of just movement building for Indigenous people, particularly urban Indigenous people. So those who have been displaced from their community would often go to Indian friendship centers in their city. And so there would be a lot of political, social organizing around them. So there's if I were to ever be in another city and something were to happen to me, I would honestly, I would call up the Indian Friendship Center and say, this happened to me and I need some support. And I would know I would get it, regardless of the fact that I'm a lawyer and probably could access other services. I would just feel safer going to the Indian Friendship Center over anything else, because they're non-judgmental. The majority of them are non-judgmental. They operate from an understanding of the context in which Indigenous people experience Canadian society, and they have a wide range of tools and services. So they have counseling, substance use issue programs, based programs, traditional programs, and they all have healers and elders who travel and they visit the Indian Friendship Center. So it's literally a connection to, say, for example, if you have somebody who you know who comes out of, so when I go to Toronto, if I have time, I try to go to the services there, because the healers that I want to see are going to be in Toronto. Sadly, it's a bigger city, but whatever, I'm not going to critique that. But that's essentially what it is their connections to services that generally are not elsewhere, so non-Indigenous centers. So I can't really say what tools or services are typically available, but it's generally a wide range of services. And if they can't provide it, they will help you figure it out. So the justice workers are super resourceful and they're usually connected to other services. And in terms of setting up an Indian Friendship Center, that's really up to the community. So the Indigenous community based in wherever it is, if you want to support that, that's absolutely something that you can do. But definitely just let the community guide that and set that up.
Yeah, thanks. I agree. Community, it has to be community led. It's not something that can be driven by external organizations or people. So just in terms of continuing that discussion with the culturally appropriate services. So the question that we have here is, what information is available as to the availability of culturally appropriate mental health services within the forensic psychiatric, sorry, I apparently can't read, facilities in the province for Indigenous people who are ultimately found NCR or unfit to stand trial? And how would Defense Counsel go about finding this out? And I share this person's question because I know that this was one of the frustrations that I definitely experienced in the beginning of my journey through the criminal justice system in connecting clients How does someone find out what services, like what Indigenous or culturally appropriate services are within the psychiatric facilities? Oh, sorry, Naomi.
Sorry.
Or both of you. Yeah, sorry, I don't mean to, either one of you.
This is a hard question because these care facilities are often at odds with defense counsel. And so I don't want to say animosity, but sometimes there's a lack of sharing of information. So it's really important to build relationships, just a good professional relationship, if you're going to continue to do this work with these services, to understand what culturally appropriate services are available. And that's just my experience just as an Indigenous woman defense lawyer, is that everywhere I go, people just don't want to share information with me, even if I ask, in a very nice way. So that would be my one tip, is that build relationships early and build them at a positive standpoint. And so if you have a psychiatric care facility in your community, to maybe reach out when there's not an adversarial proceeding happening, and to just say, hey, I just want to, explore what sort of services you have, because I'm serving we have mutual clients and I want to be able to serve them better. And that may just help build the bridges a little bit better. And then how do you, I think that answers both questions. But I would, the one tip that I would give to defense counsel is, as soon as your client is found NCR or unfit, is to get a GLADU letter right away, if that's something that they want, because the report can take a long time, and these proceedings happen within a short amount of time frame. And so you don't want them waiting for a report, but also if the GLADU letter will assist them in any way, to get it, like, as soon as it happens, literally submit the request in and say, you need a letter. Yeah,
a really, really good suggestion too. Okay, so Cassandra, I'm going to turn to you for the next few questions. So the next question in the chat is, if an individual is detained in custody, isn't it more difficult to obtain the other assistance they need, such as mental health, as opposed to releasing someone on conditions, which include seeking assistance in the community, which includes family and support networks?
Yeah, I mean, of course, that's the dance, right? That's what you're constantly trying to balance is, jail is certainly not the place for someone with a mental health issue. We, as practitioners, know that they're ill-equipped to deal with the challenges that faces. And so I'm not suggesting that sitting in jail is better than making a maybe even condition-filled bail order. But my point is that that's also not what the law says. The law doesn't say, lots of conditions or else you sit in jail. In fact, the law says we need to restrain our conditions. And so all I'm trying to encourage is having realistic conversations with all the parties, including, and that will include your client, your accused person, about what is necessary to gain bail. And if that, if the reality is that they're not likely to make bail without agreeing to certain conditions, then that's a choice that they make, right? And so you give the power to them, you empower them to say, I would rather be out with these conditions that I don't think are fair or are not actually going to help me, but I'll follow them, than to sit in here. Or maybe they don't. Maybe they would rather sit in than go out and have to do a bunch of stuff that they don't actually think is going to be helpful to them. But it's about not presuming you know what's best for them.
Thanks.
Can I also talk about the therapeutic courts? I think that came up in passing reference through a question here, and I just want to touch on that because I realized I failed to. So one of the options as well that many courts, especially the larger jurisdictions, will have now is a specialty court or mental health court, therapeutic court. There's different names for it. That, of course, is another option to try and help assist accused people who are struggling with mental health. what I find the pitfalls of those courts is that, first of all, it's only normally for diversion or a guilty plea. So if your client is adamant that they're not guilty of that thing, then that court really has no place for them. And that's unfortunate, because someone can be innocent and still struggling with a mental health issue, and maybe could have otherwise used that help. And number two is that I find, and this is the numbers game always, it comes down to resources and money. And so the streamlining to get into that program or into that court can also be a challenge for many clients. I know, for example, in London, there's certain types of charges that are almost, considered too serious to be considered for that court, and therefore those clients don't get to go into that court. And so there's challenges associated with them, but I think that's probably the closest tool that we have available to us where we can see a healthy intersection of mental health and the criminal justice system, especially if it's, here's a bunch of programming and assistance for you, because we're then going to divert the charges if you do well. That seems a little bit less, I don't know, restrictive than do all these things and then we're still going to give you a criminal record, or do all these things and then you're still going to have to do all these other terms as part of a probation order, or whatever the outcome might be. But yeah, I didn't want to fail to mention therapeutic courts, because that's an important initiative that we're seeing pop up in many jurisdictions, and I do think there's some promise there. The criticisms I have aside. So
Okay. And so overall, would you say that despite the criticisms that you have, that you would support the further creation of mental health courts and diversion courts?
Yeah, I think so, because the reality is that when you get a bunch of people into a room that kind of make that their specialty, and that's often what those courts are, is, there's people that are actually trained in mental health issues, psychiatrists, social workers, together with the players of the criminal justice system. We are more likely to get to the right answer than if it's just a bunch of criminal justice participants trying to answer questions about mental health. So,
okay.
Again, I all of this, I doubled down again earlier on with the person's consent is super important. But assuming that that's there, and assuming your client's motivated to complete whatever is being offered to them, then yes, I would support that.
So, so I'm just I know we only have 3 minutes, but I am gonna just ask this last question. Hopefully we can get some quick answers from both of you. It says, please describe some event. Oh, sorry, I'm already there. It says, it's the last question that we received. That's with the recent killing of the OPP officer in Ontario and the letter sent to the Minister of Justice, or by the Minister of Justice, in the last few days, do you anticipate any swing in the pendulum towards more stricter bail conditions for everyone, and any impacts that this might have on mental health or Indigenous people?
So if I can take it first, and then Naomi, I'll give you last say, is that okay? Yeah, I'm of course concerned about that. I mean, when that incident happened, of course, you started seeing the cries for stricter bail reform immediately from people of all walks of life, right? No one wants to see an officer killed in the line of duty. But the reality is that our bail system is in place, and it is already strict enough that it curtails, in my view, the great majority of predictable or preventable crime. What we needed to, as a society, appreciate and acknowledge and accept is that our system is never going to be perfect. So in the same way, we're never going to, I think, reach a 0% wrongful conviction rate. And the same way that there are going to be many people that are in fact guilty of things that walk, we similarly are not always going to get bail right. But there is a reason that there has literally been years and years and years of jurisprudence and a walking towards the current bail terms that we have, or the current bail framework that we have. And that's because this is what's correct. I mean, at law, when you're talking about a factually perhaps guilty person, but legally innocent person, we have to treat them that way. And I know I'm preaching to the converted, but I read portions of the letter to the Minister of Justice, and some of the suggestions there are like, for example, let's make it a reverse onus for certain types of gun offenses. And that to me is all fine and well, because really, if you understand the bail system, you understand that whether it's a reverse onus or your own onus, it's the difference of 2%, right? So that is not really going to, or shouldn't in application, swing the pendulum too far the other way. I think that the calls for changes that we're seeing are not necessary, but they're at least reasonable. And not completely lost. They're not completely far gone. So I think that hopefully with a tempered approach, we shouldn't see too far of a swing based on what I'm currently seeing being suggested anyway. But we've been wrong before about that kind of stuff. So
thanks. And I just want to turn to Naomi. But before I do, so Naomi, I'm really interested in your response to that. I do want to acknowledge that there are other questions that are in the chats in the Q&A, and I'm sorry we're not going to be able to get to some of those today because of the timing. They are very interesting questions, so I don't mean to skip over them. So I just want to give my apologies to people right now. So with that, I'm going to turn to Naomi. I'd like to give you the final word, just in terms of the question that I asked before, just how is the recent media regarding the demand that was made by the Minister of Justice from the Prime Minister regarding the changes to the bail, how is that going to impact or swing the pendulum towards more stricter bail conditions for everyone, and in particular for Indigenous and mental health people who have mental health related issues within their lives? Oh, you're on mute.
I think it's really important to highlight the fact that, these are individuals with their own cases, and that larger narratives can't just be transposed down onto the individual cases. And sometimes you have to, what we call protect the record, and make sure you call out inappropriate reliance on outside media sources that are not relevant to your client's case, and to make sure that there's no bleeding of those narratives into your client's case. And it happens, and you just need to make sure that your client's proceeding and the integrity of his or her proceeding is protected, and that outside influences are not transposed onto them.
Perfect. So thank you. So that brings us to 2:02, and I'm sorry, I wish we had all the time in the world to continue this discussion. Such an important conversation, and so many great points today that I really wish that we could spend all afternoon on. But with that, I do want to say thank you to everybody, and wish you all a good rest of the day.
thanks so much. Thanks, Jonna. Thanks, Naomi.
Yeah.